There are defining questions that investors routinely miss asking and answering when acquiring shares in a South African company holding mining or prospecting rights. This failure in the due diligence process can be the deciding factor as to whether a sale transaction is legally effective or completely void. Welcome to SA Mining Desk. On today's episode, we draw critical legal lessons from various high court proceedings involving Mamokebe Investments Pty Ltd to answer 5 fundamental questions. What happens when you buy shares in a company that holds a mining right, but the transaction was never approved under the Mineral and Petroleum Resources Development Act, MPRDA? Can a person become a shareholder simply because an agreement says they will acquire shares? Can a CIPC record make someone a director when the underlying appointment was never valid? Does ministerial consent under Section 11 of the MPRDA actually transfer a mining right? And what happens when people claiming to control a mining company continue operating while the dispute is before the courts and an appeal is pending? These are not hypothetical questions. They arise directly from the multi-court litigation surrounding Mamokebe Investments Pty Ltd. Through these judgments, the High Court developed a series of pivotal legal doctrines. Before we examine the judgments, we must understand the company at the center of the litigation. Mamokebe was incorporated on 12 September 2006 as an inactive shelf company under the name Edzam Trading 161 Pty Ltd. by incorporator Stephanus Andres Gauss, who was allotted 100 issued par value shares out of 1,000 authorized shares. On November 7, 2006, the company changed its name to Mamokebe Investments Pty Ltd. 2 days later, on November 9, 2006, Gauss transferred all 100 issued shares, 49 shares to Kaapu Stanley Pali, 41 shares to Mojodi Ramatsamele Francina. Stanley and Francina were appointed as sole directors on November 14, 2006. So from 2006, the original ownership structure was straightforward. Stanley held 49%, Francina held 51%, and together they controlled 100% of the issued shares and the board. The significance of this structure becomes clear when we look at the underlying mineral asset. In September 2010, Mamokebe obtained a prospecting right for coal over farms situated in Walkerstone, Mpumalanga, which was renewed in 2015. The company subsequently applied for a mining right, which was granted and issued in 2024 for a period of 10 years. Operationally, the Mamokebe colliery involved open-cast coal extraction, stockpiling, and commercial sales. This was not a dispute over a dormant shelf company. It was tied directly to an active, regulated mineral asset. In November 2022, Stanley and Francina incorporated a separate company, Mamokebe Colliery Pty Ltd., appointing themselves as sole directors. This became critical when in August 2024, Francina applied to the DMRE to transfer Mamokebe's mining right to Mamokebe Colliery. The litigation eventually concerned not only who controlled Mamokebe Investments, but what would happen to its primary mining right.
Now we arrive at the critical transaction. In September 2016, Stanley and Francina signed a shareholders' agreement with Alcento Pty Ltd., trading as Rubicon Consortium Mining, represented by Mohammed Adam. Alcento was to acquire a 70% shareholding, and authorized share capital was to be increased to 50 million shares. On paper, this was a major change of control. However, no prior written consent under Section 11(1) of the MPRDA was sought or obtained. Furthermore, the Memorandum of Incorporation, or MOI, was never amended under Section 36 of the Companies Act. No board allotment took place under Section 38, and no purchase price was paid. And this brings us to our first question. What happens when you buy shares in a mineral right holder without Section 11 MPRDA approval? To answer what happens to such a transaction, we look to the foundational framework of South African mineral law. Under the MPRDA, mineral resources are the common heritage of all South Africans under state custodianship. Section 11.1 establishes a peremptory statutory prohibition. A prospecting right, mining right, or controlling interest may not be ceded or disposed of without prior written consent from the minister. In Pretoria High Court, Acting Judge Labshagni examined whether the 2016 Alcento Agreement was merely voidable or legally void from inception. Relying on established jurisprudence, including Sheerhout v. Minister, Vantage Goldfields SA v. Arkomanzi, and Mogale Alloys v. Nuco Chrome, the court concluded that Section 11.1 operates as a peremptory prohibition protecting public interest. The agreement was not merely capable of cancellation, it was void ab initio, devoid of legal force from inception. Answer: the transaction is void ab initio, void from inception. Key takeaway principle: any commercial contract attempting to dispose of controlling equity in a mineral right holder without prior written ministerial consent contravenes a peremptory statutory prohibition and is void ab initio. Even if we temporarily set the MPRDA prohibition aside, could Alcento prove it became a shareholder simply because the agreement said it would acquire shares? Which takes us to our second question. Can a person become a shareholder simply because an agreement says they will acquire shares? In terms of Section 35(4) of the Companies Act, authorized shares confer no rights until issued by the board. In court, Alcento formally admitted on record that it merely expected to be vested with shares. This admission was conclusive. The court held that an expectation, or spec, does not create shareholder status. Answer: no. Authorized shares confirm no rights until formally issued by the board. Key takeaway principle: for an investor to acquire shares, they must be properly authorized by the MOI and issued by the board under Section 38 of the Companies Act. A shareholders' agreement alone is insufficient. Question 3. Can a CIPC record make someone a director if the underlying appointment was invalid? On 5 October 2022, 6 years after the agreement, Alcento purported to act as a 70% shareholder, called a meeting, appointed 4 directors, and filed a Form COR 39 with the CIPC using forged signatures. Labshagni AJ ruled that under Section 61(1) of the Companies Act, a non-shareholder lacks standing to convene a meeting. The meeting was an absolute nullity, meaning the directorship resolutions had no lawful foundation. The court established that CIPC recordals are purely administrative. Restoring CIPC records pendente lite via consent orders does not constitute a valid statutory election under Section 68 of the Companies Act, nor can administrative extracts cure forged signatures. Adopting the doctrine in BMF Assets No. 1, limited to San Group plc, the court classified individuals who displace legitimate boards via void processes and forged filings as cuckoo directors, strangers acting without color of authority. Stanley was recognized as sole legitimate director under Section 57(3) of the Companies Act. Answer: no. CIPC filings are administrative. Authority requires a valid Section 68 statutory election. Key takeaway principle: a CIPC record does not by itself create directorship authority. Although useful, the extract should not be treated as the complete legal history of a company. The underlying corporate appointment must be legally valid. While governance battles continued, the mining right itself became the next battleground. In August 2024, Francina applied to the DMRE to transfer mining right to Mamokebe Colliery. This led to Pretoria High Court case before Acting Judge Raubenheimer, who delivered judgment on 22 April 2025. The Ao Kusento board tried to interdict the minister from approving the transfer. This raised our fourth question. Does ministerial consent under Section 11 of the MPRDA actually transfer a mining right? Raubenheimer A.J. held that Section 11 consent is merely an administrative prerequisite. Legal transfer of title occurs strictly when the registrar of mining titles affixes his signature and registers the transfer. Section 13 of the Mining Titles Registration Act, MTRA. Aggrieved parties possess adequate alternative statutory remedies. The urgent interdict against the minister was dismissed, and the transfer was subsequently registered in the Mining Titles Office on 30 January 2026. Answer: no. Section 11(1) MPRDA ministerial consent is administrative prerequisite. Legal transfer of title occurs upon registration in terms of Section 13 MTRA. Key takeaway principle. Section 11 MPRDA consent is a regulatory condition precedent, while MTRA Section 13(1) registration is the final step that transfers legal title. Both must be satisfied. Our final question: what happens when people claiming to control a mining company continue operating while an appeal is pending? When Stanley obtained an interim interdict restraining the usurping directors, the respondents filed for leave of appeal, claiming execution was automatically suspended under Section 18(1) of the Superior Courts Act. In his Section 18 judgment delivered on 22 April 2026, Labouchegne A.J. held that governance interdicts regulating representation pendente lite are interlocutory and not automatically suspended. Evaluating Section 18(3) cumulatively, the court held that ongoing extraction of a finite mineral resource causes irreversible physical depletion. Coal extracted during litigation cannot be replaced. Combined with outstanding safety notices under Section 54 of the Mine Health and Safety Act, these factors constitute exceptional circumstances justifying immediate execution pending appeal. Answer: mineral assets can be protected from irreversible resource depletion during litigation via Section 18(3) execution. Key takeaway principle: the physical consequences of continued extraction can form part of the cumulative circumstances considered by the court. Strategic lessons. What 5 strategic lessons must investors, directors, and legal advisors draw from Mamokebe? Lesson 1. Check Section 11 MPRDA before signing share deals. If Section 11(1) applies to the transaction, do not treat ministerial consent as an administrative detail to be addressed later. Build regulatory compliance into the transaction structure from the beginning. Unapproved deals are void ab initio. Lesson 2. Verify actual share issuance under Section 35(4) and Section 38 of the Companies Act. An agreement to acquire shares does not necessarily establish shareholder status. There is a difference between commercial intention and completed corporate action. Ensure the company's MOI and share issuance processes are properly authorized and completed. Maintain an accurate share register and a clear and current board records. Never rely on CIPC extracts alone. Trace underlying resolutions, authority, and registers. A CIPC record is an important record, but it is not the entire legal history of the company. Administrative record cannot cure an underlying void corporate act. Lesson 4. Distinguish Section 11 MPRDA consent from Section 13 MTRA registration. Section 11 consent is an administrative prerequisite. It does not by itself complete the legal transfer of the mining right. The legal transfer occurs through the statutory registration process by the Registrar of Mining Titles under Section 13(1) of the MTRA. Do not assume that obtaining one automatically completes the other. Lesson 5. Protect mineral assets from irreversible resource depletion during litigation via Section 18(3) execution.
The important point is not that every mining dispute will automatically satisfy Section 18(3). The important point is that the physical consequences of continued extraction can form part of the cumulative circumstances considered by the court.
The Mamokebe story demonstrates a fundamental principle. Commercial intention cannot override statutory legality. In South African mining, corporate control, regulatory compliance, and mineral right ownership are legally interconnected. The parties may intend to transfer shares. An agreement may record that intention. A CIPC record may later reflect a disputed corporate position. Individuals may begin acting as directors. A minister may be asked to consent to a mining rights transfer. But each legal consequence still depends on compliance with the statutory framework governing that particular step. That brings us to the end of today's video. Thank you for joining the SA Mining Desk, where mining law is clarified and simplified so that we may all participate in the exploration of our common heritage, mineral resources. If you found this useful, subscribe, like, and engage in the comments. Until next time, take care.